Okay, it's 10 o'clock. We will call the Sawyer County Administration Committee to order. We have roll call, Madam Clerk.
Reed Schumann.
Here.
Dale Schroeder. Here. James Slender. Ron Kinsley. Here. Tom Duffy. Here. You have a four.
Record indicates that, Madam. Number 3, certification of compliance with open meetings law.
This meeting has been noticed to the public and news media as required by section 19.84 of Wisconsin statutes.
Thank you. Meeting agenda has been presented. Public comment. Got one person. If you have anyone online, we'll start with Ms. Zilmer, please. Please state your name and address.
Thank you, Mr. Chair. Linda Zilmer, 902 Holly Hill Lane, Wisconsin, Edgewater property owner. And I have a couple of general comments for items that are not on the agenda. And then also would like to recognize for item 13 when you get to that for the recommendations.
Yep.
First of all, I have made a request before this committee and other committees in the past to have the county supervisors who are representative on outside entities representing the county to do regular reports back to committees or the full county board, so that there's greater awareness of what's going on with those entities. And so whether it's the Hayward area VCB for routine matters, or something that I just learned about this week where Indian Head Community Action Agency is selling some of their housing properties. I found the listings in Washburn County, but I also found that properties were sold in. So that affects workforce housing and affordable housing. And I think the full county board should be aware and also maybe do some more work on community action agency. What your experience here is in Washington County. Second item is I'm concerned as to who the public should take concerns to, whether it's supervisors or the administrator. I understand the administrator reports to the county board, but when issues are brought to both the county board and the administrator and they're not responded to, whether it's an ethics committee meeting request or other matters, the public needs some guidance as to who to take issues to. If you could talk about that and let us know. And specifically, we have an ongoing situation with the board adjustment as it's zoning matters in Sawyer County. There was an appeal that board heard. There was an outside counsel representing the BOA at that meeting who issued a decision letter that was a month late, or not, I mean, it was a month from the time of the hearing, and I don't believe it accurately reflected the decision or what happened at that hearing. So I have attempted to follow up with administration and don't get a response. But I did not feel it was appropriate for me to respond to that attorney and possibly county fees.
Yeah. Them on a reporting schedule. Okay. All right, moving on into number 6, approval of meeting minutes, September 9, 2021. Mr. Kinsley? Mr. Duffy, second. Motion by Mr. Kinsley, second by Mr. Duffy to approve the meeting minutes, September 9, 2021 as presented. Any further discussion? Thank you, Mr. Schlender. Signify by saying aye. Opposed? Motion carries.
I need to abstain on what the motion was.
Yes, sir. Moving the meeting minutes. Okay, number 7. Veterans.
Okay, good morning.
Good morning.
For the Veteran Service Office in September, we had 441 phone calls, 419 letters, emails, and faxes, and 168 office visits. Our disability and compensation and pension claims, we submitted 92 of those claims and received a little over $327,000 back in for claims decided in the veterans' favor. So last month, the committee asked the question of Gary, how many claims do you have that were denied? So I went back and I looked, and this is what I have out of the claims that I submitted this year. We had 5, and I'm going to go right down the line with them. I wish I was there, and I apologize for not being able to be present. But for the first one, it was a compensation claim, and this one is one of those that there's no scientific or medical evidence established to support the claim. And what we're talking about is presumptives, presumptive conditions for, in this case, it was Agent Orange. It's not a presumptive for Agent Orange. There is no medical background or documentation or studies to support the veteran's claim that the disease that they were claiming was contributable to Agent Orange. But we filed the claim anyway, and it goes back, and I've mentioned this before, but in many instances, it's better to file the claim because in the long run, this veteran is probably not the only one to have this condition. And that is how the presumptive list has grown over the years for our veterans with Agent Orange. Just recently this year, bladder cancer was added, hypothyroidism was added, and that was because the number of claims by veterans who were in country or blue water that were exposed to Agent Orange were too numerous to deny that there was a correlation between their service and that disease. Does that make sense? So we file it anyway. We set up the numbers and it's for potential future review. In this case, for the veteran, it wasn't going to gain them anything because they are completely maxed out with compensation through the VA. There is no more to gather, no more to garnish or garner for him or for his family if he passes away. So all the markers that he could possibly set have been set, but we set up the numbers for other people along the way. So any questions on that one?
No. Don't appear to be.
Okay. All right. So the second compensation claim is right along the same deal. It is not a presumptive, but we filed it anyway. This person wasn't maxed out, but so in 2 years or 3 years, if they come back and say that this disease that we filed for is now a presumptive, there's a law passed for Vietnam veterans. It's called the NAMER Act. They have to go back. The VA has to go back and make that right for the Vietnam veterans. That does not apply to Gulf War veterans or anybody else. But it was a lawsuit that went forward, and the VA basically lost. Then the reason we filed this is we knew it wasn't going to go. It wasn't going to go through. But we set it up for the veteran and the veteran's family for potential future review if it becomes a presumptive itself. All right, the third one is different. It is a pension. A pension claim, in this case, the veteran's income and assets were too high, and medical costs, which can offset their assets for a pension to apply to be awarded that pension. It didn't bring his this person's income down enough to be able to be awarded. So and the pension is a needs-based benefit. It's not something that's just automatic because you would like it. It has to be based on need, and we could not prove that. And I knew it was close when we sent it in, but my job is not to say no. My job is to help support that veteran and push it forward. But when it's all said and done, the income was too high. The fourth one was a compensation request for increase for a disability for that veteran. And you know, it's you never really know where you're at. You know, a good case would be like a hearing claim. The veteran will, you know, come in and say, you know, my hearing it's been 5-6 years. It's definitely gotten worse, Gary. You know, I'd like to file a claim for an increase. So, you know, we'll do the paperwork. We'll send it into the VA. But in this case, the veteran disability did not increase enough to bring it up to the next higher threshold, according to the Code of Federal Regulation. So, I mean, and it's there. And when I get those with the veterans, we'll go back and take a look at it. If it's something that I think we can go back and say, no, you didn't measure properly, then we'll go back and fight. But in this case, it wasn't. It clearly was not there, but we wouldn't know until we got the medical people to go back and review it. And I obviously I'm not a doctor, but you know, like I said, and my job's not to say no. So it's to help fight for that veteran and push it forward, and that's what we did, and we fell short. On item number 5, in this, there's a temporary 100%. Basically, for a veteran, you get into this stuff. You get into hips, knees, replacements for hip or knee replacement, or oh my gosh, I don't know, whatever it could possibly be for like a convalescent. It's a convalescent type compensation. And it's only for a set amount of time. In this case, in this veteran's case, it was a 30-day convalescent. The Code of Federal Regulation provides that with the doctors. It is set there. If there is a need for an extension, you go back to the medical people. You know, you basically a doctor going, oh, you know what? We'll take a knee as an example. We put the knee on backwards or sideways or whatever. And it's not, you know, it's not healing. They need to go back and fix it. Well, we would take that evidence and we'd go back to the VA and ask for an extension to that. And that's basically what this was the veteran wanted an extension to what was already set up by law. And again, there was no medical evidence to support that person needed to be remaining at that temporary 100%. So financially, I mean, it looks really good because, you know, you're looking around, you know, $3,000 a month versus maybe, you know, $600 a month or $500, whatever it could be. So, but that's basically what happened, and those are my 5 that were denied. I had a 6th. I was going to put it on there, and I took it back off. I'll talk about it a little bit, and it was a pension. It was a survivor's pension. For a widow. We've been at it we went for an increase, and it turned into a really mucky mess for about a year and a half of fighting with the VA back and forth. Well, I got denied again this year, and we kept fighting it. Ended up, we turned it around, and succeeded with the VA. And what was on the line was about $17,000, a little over $17,000 in pension benefit that the VA thought they were going to, you know, they needed back. And in fact, we got that back. And the survivor, the spouse is still on a survivor's pension, and it has been increased slightly, which is all we wanted in the first place. And we're good to go. So, out of again, going back to the 92 disability claims at the time I printed this, 5 are denied, and those are the reasons why. Does that make sense to everybody? Any questions? Okay.
Gary, I have a question though. Is there an appeal process for any of these denials, Gary? I see some are under, you know, like future review, potential future review. Is that? Yeah. I'm sorry. Maybe my wording maybe it was confusing. So, like I said, I just put that in there because it is a potential future review if
because those two were Vietnam, so that's the namer, where they have, by law, they have to go back if the VA comes back and says, you know what, we've got 200,000 veterans that all have, I don't know, a big thumb disease. And, you know, we're going to have to make that presumptive because of the numbers support that there is something to this with the Agent Orange and big thumb disease, if you will. So that's all I put that in there. That's not VA words. Those are Gary's words that I put in there just to try to explain, you know, I'm doing this because there's a possibility that they will have to go back by law for those claims that we knew weren't going to go forward at today's date because of the law. Now, to go back to, is there appeal process? There definitely is an appeal process. The appeal process can go up to the Board of Veterans Appeals, and that's like DC, Washington DC. There's a traveling board that goes around, but that's very slim. But a lot of cases, and our county's got, you know, had plenty of cases that went up to that board in DC, and where it was finally decided, you know, yay or nay. And for the most part, I don't remember getting up to the Board of Appeals and losing. So, and in our service organizations, I'm nationally accredited, but I'm cross accredited with the American Legion, Wisconsin Department of Veteran Affairs, and the VFW. And we have representatives, lawyers in DC that will represent that veteran. The veteran can go at their own cost out there for their own day in court, if you will, with the board. But for the most part, I haven't seen that happen. The veterans lawyers have, you know, our lawyers for these service organizations have represented as well. So, but that's all the way there. But there's two other appeal processes before that we get into where I will fight and argue with them on basically a straight up claim going, no, you did this wrong, or I believe you made an error, and here's where the Code of Federal Regulation applies here, and you interpret it this way, and it really should have been interpreted that way. Or there's a clear and unmistakable error. What you stated is not here, it is here, and we've turned stuff over like that and never left the office. And after that, it gets, like I said, you go up to the Board of Appeals and fight from there. So, does that help?
That does. Thank you.
Yes, sir.
Anything else, Gary?
Pardon me, sir?
Do you have anything else?
No, I do not. I do not.
Is there any questions for Gary, concerns? Thank you very much.
Yes, sir. Thank you, gentlemen, ladies. Yep. Bye-bye.
Mostly operational things, although one thing that we just did earlier this month was
They obviously might still have a working phone line there. I mean, I know they're going to be giving immunizations there now coming up. And
yes,
okay.
Actually, we're going to put the telephone out there today.
Okay. Anyone have anything else? Report, Mike. Meeting board policy discussion action from our previous discussion, and I'm just wondering, were you there or were you on?
I was
Okay,
at the
so you
board.
know what the discussion
Oh, I'm
was.
sorry. No, I was
Virtual?
I was virtual.
Sure.
With permission.
Oh, yes, Mr. Slender, I'm sorry. Oh, okay, I thought you wanted to speak, but,
I do, but not right
okay. So are there any comments, concerns? I guess
I-
the
yeah.
main, what I got out of it was they wanted to get away from getting the chair's permission to be virtual.
now. I don't know if it's chair permission. I think it was just removing the permission component. I think it was just making notice because if there's, I mean, I think it's more of a task for the chair to have to give notice so that the chair knows if there's going to be a meeting, or if there's going to be quorum. I think that's what it was, right?
Mhm. Yeah, I think that's a fair statement. I did not make any changes to the rule as it appeared before the county board because I wasn't sure exactly what the board was looking for, and then obviously to get the input from the committee. And so if the committee's input is to make the revisions regarding notice to the chairs, I can certainly do that.
Like letter C, Rebecca.
Okay. So
That's where you and I are talking about.
Mhm.
From the county board chair, no later than 24 hours prior to the meeting.
Right, so provide notice to
Yeah.
the county board chair.
I like that.
Any permission to provide notice. Add that for committee chairs as well as the
Yep.
board.
That was my next question.
And then we're going to remove the cap so that there's there's like 3, and then you're subject to some kind of ethics violation or something, right?
Yeah, so
No, I'm serious though.
No, you're right.
no, there was at our, I believe it was the August meeting of admin, there was lots of discussion in terms, well, even previous to that, as a board, how do we capture that enforcement? So how I attempted to do that was, and take that number 3 trigger, if you will, and if there was 3 missed, then have it go to the ethics committee again as an attempt to preserve some sort of enforcement mechanism while also giving it to that being said, those provisions, again, from a legal standpoint. If that out,
Out.
because that's in the current rule.
Okay.
And then in sub F, this is more of a general holistic non-compliance provision. So again, the number 3 specific is out, but it still captures a trigger of non-compliance. So if somebody does not comply, what is the mechanism for enforcement, or what is the mechanism for review? So that is then the board chair will step in, or the committee chair, if we're talking about committees, and discuss the rules and expectations with that board member as kind of a step 1. And then step 2 would be referral to the ethics.
So it would be at the chair's discretion then.
Yes. That to
there, I think, because it's a lot easier to run the meeting.
Mhm.
This is a technology that's been brought forward for us to use almost every meeting you get to, they can have a virtual meeting, so maybe that 3 meeting should be out, and maybe if people are gonna be virtual, we should let it happen. Sure to know that they're going to do that, but I think if you go back to our rules, clerk, so that whether it happens or not, but it's just a yes, that's, I like people there, but I guess I'm leaning toward just that they go virtually, but I need to know.
You're okay with chair versus getting permission from the chair. Okay, Mr. Duffy.
Oh, I speak against the resolution for a couple of reasons. First of all, if it's not a problem. Chair, there's no guidelines. Yes. Saying yes to all of them. And so what do we have accomplished by the whole thing? Then you go back to line. He's concerned about the virus and he's not going to show up. So you're going to find some members. A big problem here with what we're doing. I don't see people. So that's my comment.
Thank you, Mr. Duffy. Mr. Schlender.
So I respect Mr. Duffy's comments. The reason why we need to do this is because we have this based on this is pre-technology kind of rules, and we need to adapt as we go forward. Some people just cannot be present for whatever reasons, whether it's a virus, whether it's childcare, whether it's they're confined or quarantined, or they're whatever their circumstances are. We should respect them for what they are, because we all took an oath to be responsible. What I would put in here, the 3 things that I thought were crucial to this one was remove the cap of 3, because that triggers some kind of enforcement mechanism that is clearly not defined, and it puts as Duffy was saying, puts a burden on the chair. That, so what am I going to do if I have someone that misses 3 meetings? Tell them to be at the 4th meeting? I mean, I don't know what I can do, because we're all of equal rank. Second thing is removing the permission component, because we all accept the responsibilities, and so there's a presumption that you're gonna uphold that. Creating some kind of permission gets like an authority. You're adding authority to something that I don't think should be there. So notice, just letting them know that they're going to be there. And I got to tell you, everyone does that anyway right now. So just putting that in there provides for future committee members to understand what their responsibilities are. The one thing I put in here, and this is something Mr. Kinsley kind of made me more aware of this, we should write in there somewhere, it's presumptive that you're going to be there, and that it's not automatic that you're going to get Zoom. So they should, if they're going to appear by Zoom, that should happen for every meeting and every occurrence. It's presumed that they would be there, because that's what our expectation is, and it's for meeting management. And then as a subnote, with what Mr. Schlueter had said with his concerns is, we have to start training county board members that if they're going to be Zoom, they have to get permission to speak and not just jump right into a conversation, because that disrupts the flow. It makes it hard to chair the meeting. And then also it makes sure that we have people staying on topic, So, whether there's a delay in their broadcast or whatever else, that's their responsibility. If they're going to appear by Zoom, and they're asking for this additional requirement of seeking permission to address. I mean, we all raise our hand. But, I can't see who's going to raise their hand unless, Mr. Colson helps me with that. And if they feel frustrated to jump in there, they got to be out of order, because we have to have some kind of semblance of going forward. So those are the things I have with that.
Yeah.
I'm in support of this motion with those provisions that would be in there.
Okay, and Rebecca, where would you add this for something that you hear in person?
Okay, so
Where do you want to add that?
Yep, if you look at line 51,
Shall be held in person.
Yeah, shall be held in person. However, the board recognizes some circumstances may require virtual. So if I could add at line 51, all county board meetings shall be held in person. There is a presumption that all board members shall attend in person.
Okay.
So kind of strengthen that clause.
Okay, line 51, okay.
Mhm.
And the cap of 3 is already out?
It is
Correct?
already out,
Okay,
correct.
so that's answered.
Mhm.
I want to hear from Mr. Schlueter. Have any comments on this now with these edits?
toward Mr. Duffy's comments. Is there anything in the board policy now that we would need to limit or eliminate? Is there anything in the board policies now that we would have to eliminate to assume these presumptive rules? Let's say this right. If we don't do anything, and I am leaning towards that because I don't want to get into having 5,000 rules of etiquette wrote down that county board members are supposed to follow. I think it's presumptive that the person gets on the county board and we try to blend in with the other county board members, treat each other respectfully, so on and so forth. And it's also the duty of the county board members that were already on the board before the new person to quote unquote kind of show them the ropes and this is an unwritten rule. It's something that has worked in the past and is good for a good flow of discussion at meetings or whatever. But is there, if we do nothing other than say we're not going to do anything, we're just going to let this whole thing drop, would we have to go back and change current policies to say we have to do something?
Mm-hmm.
But that would be easier than trying to move forward with a new policy. Or more. No.
I respectfully disagree with you. I think the way that the board rules read now are very inconsistent between boards versus committees, what those rules and expectations are. You have the rule right now that board members cannot attend more than 3 county board meetings by virtual means. That was suspended until July 1st. I don't know for sure, but I would suspect that you would already have, or you're going to be very close to folks that are already going to be in violation of that if you count July, August, September, October. I haven't done the attendance math, but okay, so then let's just assume there are. Boom, you've got people in non-compliance with the rule already. So that's another cleanup. And I understand and respect your concern regarding the number of rules that supervisors have to follow. But in this instance, this really cleans up a lot of the confusion that's already in your rules. So I would say this is actually better and easier and more workable for your supervisors than what you have here in the current policies.
And I agree with her. This really cleans it up. And Mr. Duffy, I think this puts less on the board chair when we remove that cap of 3. And then it kind of just leaves it at our discretion if we have someone we feel is abusing this. So I do really like this change. And I like that it's going to mirror the committee rules as well. So the board and the committees will follow the same rule, that we remove that cap of 3, that we are presumptive that they appear in person. That's what we would prefer. And that they give notice to the chair that they're going to be virtual versus getting permission. That this looks good.
Yeah, the other concern too, just in addition to the workability of the rules, there is a legal issue of granting. You have to have permission in your rules in order to conduct virtual meetings. And that became a tremendous issue for many counties when the pandemic first hit. You do have that in your rules. However, if you decided not to go with this rule change, I would recommend that you make other changes to your existing rules just to strengthen those up. So it's clear that the board has authority to hold those virtual meetings, and committees too. Obviously, when I say board, talking about committees as well.
Mr. Duffy.
Thank you, Chairman. I guess what possibilities do you have, reasons you have to deny anybody the right to appear live by Zoom? And the point is, if you grant it, why do we even have it? Why? It's just calling you is just a matter of form. We have to do it to satisfy the law. And you have no reason to deny it. Can you think of any reason why you can't hear by Zoom? And if you can't, then why do we even have it? Right? Just to have another thing, another step we've got to go through that doesn't mean anything. If there were some rules by saying the chair can refuse if you do this, this, and this, or don't do something, but you almost have to. You almost have to have it. It just puts more burden on the chair, and it's kind of a meaningless step, I think.
Okay.
There is a circumstance. So someone doesn't show up for, so I've had some attendance issues with econ, and there was actually a discussion at the beginning of our last term, at the beginning of this term, to delete that committee because there was a feeling that that committee didn't have any purpose. It wasn't that important. And so if I have a committee member that's not showing up and they're not there for 3, 4, 5, I mean, I stop or else I stop again. But if they ask me for permission, then I can say, no, you don't have permission to appear via Zoom. You need to be at the meeting. And then if they don't, then we got an action that we can take either with Mr. Hoff or with the ethics committee. And so, I mean, these are all worst case scenarios. And so I'm hoping that we never have to ever actually deploy that. But there are going to be circumstances where we have people that either don't take this seriously, or in this instance, our current composition of our board, almost a third of them have been appointed because of people resigning. And they resigned for different things that were, they couldn't come through, or, in one circumstance was unfortunate, right? And so whoever comes on after that, they didn't go through the election process, and they go through the same process. They want to go through it. I don't know. I think this is necessary. I think this is a necessary step. I don't think it's superfluous. I think I agree with both Mr. Schuman and Ms. Roker that this streamlines it. Actually updates the policy, because now it's reflective of what we have in terms of technology now. 3 years ago, if you told me we had peer via Zoom, I don't know what that would have meant, and I don't think we would have had the technology. So Mr. Colson has actually done tremendous steps to make sure that we have this platform available to us. And we need to adapt to the circumstances that we have, and not make our circumstances adapt to our rules that were passed, in 1990 or 2010 or whatever else.
15, thank you.
Mr. Duffy, yes, sir.
Mr. Chairman, again, Jim's point. And putting the facts to a case here, we'll get client this and that, who said he will not appear as long as his virus is there. So what are you going to do? You're going to say, I won't give you permission, or you let him appear?
No, I think that's as board chair, I think that's a legitimate concern, and I'm going to allow Mr. Bissonnette to appear by Zoom. He seems to know the system well, and raises his hand when he wants to speak, and he's always controls his mute button. How's that, Mike? So yeah, but I understand, Mr. Duffy. There are some legitimate concerns, and I would certainly allow that. So I'm entertaining a motion to approve this board rule changes with these edits I mentioned before, and you got them, Lynn and Rebecca?
Yep.
Okay.
I approve it as long as we have those 4 things I asked for. They're in there.
I have only notice to the chair, not permission. That's line 69. And then again, mirroring that to committees. Obviously the note.
Remove the
meeting
cap of 3. Yep.
Yep. And a presumption of in-person at line 51.
And then the 4th one is just we got to get people to respect when they're going to be on Zoom. If they're going to be on there, then they're going to be respectful and not just bust in and blurt out and put stuff in there. So
yeah,
the big thing that comes up that throws me off is when we get seconds. So we call for a second. We should give that opportunity to someone who's present in the room first, and if we don't, then we open it up for the people around Zoom. Otherwise, we got people just yelling.
Mr. Kinsley.
Can I just ask one thing? You said notify the chair. Sometimes you can't get a hold of the chair. And I think in the past, we've also used administrative words, right? That's acceptable.
Notify the board or notify the proper something. I don't know.
No. Yes. Mr. Schluter.
As you said, somebody who just starts talking, talks over people. How do you control that? Just shut him off. Now go to a live attendance meeting, like, county board meeting, if somebody continues to do that, we can shut off their microphone, but they can still speak loudly and be interfering with things.
And then how do we handle that? Because I mean, that has happened before. That's Robert's rules. You strike them and you put them out of order, and then you censor them, or you have the record stricken or whatever else.
But they can still sit there
I
and.
mean, we're not going to beat people up. But
No, but that's my point. We don't really, we have something more that we can do for the Zoom attendee than we do for the in-person attendee,
benefit of being at the meeting.
but it's put a burden on the Zoom attendee that you can't put on the in-person attendee.
We also put 3-minute limit on citizens addressing the board. We also limit their ability to participate in there. So I mean,
Yes,
it's
but
not like we
we're-
don't
but
have restrictions.
We're consistent across the board on that. This is consistent.
It is actually consistent. I am, and Mr. Duffy will attest, right? You will attest. Have I gone long in the tooth when I've been speaking? And has there been efforts to try to get me to refrain my comments? There's been many attempts, either you're in the meeting or attempt to cut me off from talking, or there's been conversations afterwards. I mean, it's our responsibility. I mean, we have this freedom of speech, but we also have a responsibility to participate. This doesn't change that.
Well, it makes it
What about the
easier
language?
in the Zoom situation, just click and we're not gonna hear from you.
And that's why they have the option of participating in person. Zoom is an alternative.
By the way, I never tried to refrain you from speaking, I just tried to show you.
Yeah.
You get the-
You pray, please, Mr. Schlender, 25 words or less.
I'm
Yeah.
guilty of that, sorry, Jim. How we're gonna add Mr. Kinsley's comment that they, they notify the chair. Do you want to add they notify the county administrator, Mr. Kinsley, or how would you like that? Does everyone agree with that?
Well, I mean, if someone tells Tom or tell Lynn, they're gonna tell the chair anyway, so
Right.
they're gonna be notified, so.
Biggest thing is this, do get notified, that's I guess my main.
I've got, if you are continually disruptive in attended meeting, punishment is from now on, you have to attend by Zoom.
There you go.
Okay, so I've got a motion by Mr. Schlender, correct, with those four edits, and you've got them, Rebecca and Lynn?
I do. Can
Okay.
I just make one more brief comment?
Yeah. please.
Okay, my apologies, I'll keep it short. At the August meeting, and then at the board meeting, I believe too, there was discussion regarding conduct on Zoom. And so I did include that paragraph to reflect and just to reiterate that board members are expected to still prepare if you're via Zoom, conduct yourself accordingly. So those same rules of etiquette and conduct that are expected in an in-person board meeting also apply to Zoom participation.
Okay, so I'm looking for a second from the motion. I'll second it.
Do that?
I would. So is there any further discussion on the motion to amend the board rules? And you've got them all in, so I don't miss anything when I
We'll
say it,
confirm with
Rebecca, right?
Rebecca.
So I don't need to repeat it. Is there any further discussion? If not, all those in favor signify by saying aye.
All right,
Opposed?
Aye.
Let's do a roll call, because that was too close. So in favor of the amendments to the virtual meeting board rules.
Okay, Dale Schleter,
We're in favor of the amendments. the
Yeah.
amendments we just made.
Yeah, are you in favor of this motion?
favor of the motion for the resolution.
So,
This is a motion to approve the resolution.
Which includes those edits.
okay.
Tweet Schuman,
Yes.
James Schlender,
Yes.
Tom Duffy,
No.
Ron Kinsley,
Yes.
3-2.
Okay, motion carries. Thank you. All right, and you're good with that then, Rebecca?
Yep.
Okay,
I'll
moving-
compare notes with Lynn. So get it
Okay,
for the
moving
board
on
meeting.
into number 10, Human Resources Report. Rose, Tom, are you gonna get it?
Yes, I will cover a couple items here. HR director is currently in interviews right now as we speak, trying to get us some staff. But she did send some notes to cover here today. She's interviewing a part-time custodial position currently. There's some others. We've got about 10 open positions currently that are available. They've been posted. Again, as you've heard at a lot of committees, of course, we have not a lot of applicants for positions. We do advertise on our website, on Indeed, on Wisconsin Counties Association, Department of Health website, Glassdoor, the local papers, local school, LCO College Job Board, and Handshake, which is that goes to all the UW colleges and the LCO Job Fair. We'll also be attending the Veterans Job Fair on October 27th. That's at the Veterans Community Center. We'll have a table for Sawyer County to talk about working for Sawyer County and the wonderful opportunity that provides. The Sheriff's Department will also have a table there to positions in their area as well. Next week, they'll be interviewing for the elected official deputy position. It's in the clerk's or treasurer's office, that one. That's the treasurer's, okay. Health insurance, we did get the health insurance quote back late last week. We're still looking at that and putting that to bed. We came out a little bit more favorably for once than we had anticipated. We always expect the worst and hope for the best. We had in the budget increase of 10%. We're actually going to come in at about 4.5%. The good news is the WCA put in a bid for us this year. They opted not to a couple of years ago. We went with a different insurance company. But I think we've had good experience with WCA in the past, and we'll be going back with them for the 22 year. So that should be beneficial to employees. And that concludes the HR update, unless you have other questions.
Okay. Anybody have anything for Tom? Thank you, Tom. Number 11, 2022 budget status. Administration committee budget. Is that Mike or you, Tom?
Go ahead.
Mr. Chairman, with your permission, I'd like to hand out.
Oh, yes, sir.
It's the exact same information as on your packets. It's just sorted in an easier to understand format. It doesn't have all the little subtotals that that report does. It just shows each department, every line item. So it goes to the next department.
Thank you, sir.
We tried to include in the report departments that this committee would have jurisdiction over. It would include county board budget, administration budget, county clerk budget, HR budget, IT budget, corporate council budget, libraries, and veterans budgets. Kind of in summary, county board budget is virtually the same, slight increase. Administration budget, we actually decreased it a little bit. Regarding some of the travel and continuing it, we took a little bit from there. County clerk's budget is up about $25,000. Probably a couple reasons for that. First, it's under the county clerk's direction, 8-hour-a-day position. And we made some changes in some of the election expenses and reimbursements. I don't know if Lynn, you want to maybe address that a little bit?
It mainly is in relation to how we collect reimbursement for programming of election equipment during an election. We do have plans now of having at least 3 elections, potentially 4 next year versus 2 this year. So that's naturally gonna increase anyway. But now, according to statutes, we're charging municipalities for a proportionate share of programming on contests or races where they have contests on the ballot. Otherwise, the county picks up the tab for all state, federal, and county elections.
HR is up a little bit, just mostly in the personnel cost category. IT budget is up about $66,000 over the 2021, and I'm talking about the levy.
It's primarily due to increased security monitoring. That's a ransomware out there now that's huge. And additional monitoring and software to help mitigate that serious threat.
The veterans budget is coming in with a 0 increase. The libraries, see those. Corporate council budget we did. Next year, really, when we get around to passing whatever number those are in that resolution. A little bit of IT equipment. So
Understand why we're paying $200,000 to a library that has its own outside fundraising capacity. Subject other agencies, especially from the economic development side, to their efforts to raise money. And then the library comes in and says, well, we need this because we need it. And also asking for additional money on top of that. So I'd say that in previous years, I really didn't make that much of a deal about it. I mean, I never liked what seemed to be just do this because I'm asking this, but we actually have some real needs now. And the Criminal Justice Coordinating Council is going to be dealing with, I think we have a contribution from the tribe of 50,000 or something. That's the cost of it. The expected cost of that. And so we're looking at $120,000 or $130,000 that we're going to be expending in interest of providing direct services that provides direct benefits in jail.
Something like, something that, you know, I hear from maybe the board about. Same thing with the library. The library has been funded by this board at the 200. The reason was to increase. So that was my point on that. So this month. Now, you have any different changes I made. On these issues. Thursday, we'll present them. You'll have another opportunity at hearing at the member budget adoption. For the court order. Funding sources such as
decide not to do anything. Still have
version 3 up. Version.
Discrimination resolution, discussion of possible action.
Vaccinated and I'll get the booster when I'm eligible. Everybody I know has made efforts to be vaccinated. This is not to argue against vaccination. My concern is that if we hire somebody with the idea that they're going to conduct the job, and then we change what those expectations are and threaten their livelihood or their economic viability with an extra component, I got a concern. And there's already being contemplated in the same mandate exceptions for religion, exceptions for medical conditions. Then if we're not going to make everybody do it, then why make anybody do it? And I think that the county's position should be we should be encouraging people to be vaccinated, but I do not believe in making them be vaccinated. I think that's outside the scope of our responsibility as employers, and that if the federal government is going to hold us hostage, so we've already expended money with a promise from the federal government that the money would be restored. It's our responsibility to take up with them in terms of that. That came up was that I didn't want it's towards county supervisors, and that was appointed as safety because our ambulance service asked for some impact the economic livelihood of the county. So that's all I got to say.
Okay, Ms. Roker.
Thank you.
Legal opinion.
The county board that encapsulates its policy review. However, we have to have full state. My recommendation is we can resolution with the clear understanding that it is a advisory only, and it does not have any legal effect. So for example, if the, utilizing the ambulance, the EMS workers, if there was a mandate that came down either from the federal or state government, which would preempt any county's ability to act, this document would not create a cause of action or any legal protection for an EMS employee. So again, this document can set forth the policy consideration of the board, but it does not and cannot create any legal authority. And again, that is based on issues of preemption and the fact that the county just simply does not have statutory authority to create any sort of legal binding requirements in this realm.
So did you make any edits to this then?
I did. I actually spoke
Is that what's presented here with your edits?
No. So in speaking, I reviewed it. I spoke with Andy about it, and then also had some follow-up discussions last evening. I'll make these changes before so desire. My recommendation is to strike at lines 31 and 32, where it indicates the recitals above are true and accurate. The reason for striking that provision is because I did not do a thorough legal review of all of the references. So for example, the Fair Employment Act and all of these other provisions that are cited. Also, there's also concerns regarding certain references to, for example, the protected classes. I mean, yes, certainly there are protected classes recognized under the law. However, the interplay with a protected class and a vaccination issue is a very complicated issue. And so therefore, I didn't want, or I wouldn't advise that the statements in the whereas clauses be deemed true and accurate. To paragraph 2, I would recommend adding just again, an acknowledgement that it is the viewpoint of the county board that personal medical history and immunization status shall not be the sole reason for denying or terminating employment.
Are you talking line? Now, are you talking? You were on 31, 32.
Yep. So strike it. Line 34 is it now? That means but your duties are and certainly that is the obligation of all public officials, but I don't think there's any harm in
35.
yeah.
Right there.
That's not an exact quote on the language.
Right.
I'll have to read that a little bit. Certainly, we don't want to do something. A statement of the committee's still, we don't want to do something that could be interpreted or be argued that is going to create some sort of liability for the county, i.e., even though the county is saying this is just our opinion, somehow the county engaged in some sort of preemptory activity. That in this day and age, that is not completely unforeseeable from my perspective. So that clarification would simply reiterate and strike down an argument from a preemptory standpoint.
Well, it hasn't been seconded, but
No, there's no motion yet, sir.
So
I'm just allowing discussion here.
Yeah, to speak against this issue. It's a matter we want to state our opinions. But what concerns me is that next month, let's have another resolution to favor or oppose abortion. The next month, global warming, then carbon tax. All these issues are out there. Personal feelings I feel strongly about, but I don't think it's the purpose of the county board.
I'm gonna allow this.
Legislatively at federal and state level, and start maybe thinking, instead of doing a resolution, how the county will accommodate employees who, whatever the medical, religious, or other exceptions that'll be applied to employees who wish to do that, or to accommodate an employee who may not fall into an exemption. Yes, there are a lot of different opinions on this. I do not think the resolution is appropriate to go forward, and it has changed since Monday. Monday had some sites that were not true.
And I appreciate Ms. Roker's analysis, and I respectfully disagree with Mr. Duffy. I think these are issues that are specifically that our constituents respond to. They have to, they need a voice, and as elected people, it's no, don't like the methodology or the rationale or the restrictions that are put in with vaccinations. We're making steps to address social distancing. We're vocalizing some of the concerns that we have for vaccinations. The need for change in government and in society starts with someone speaking up. And sometimes it's the leadership that is in place that has a responsibility to speak to an issue, whether they agree with it or not. And so I think this resolution is timely. I think it's appropriate. I agree that it doesn't create a legal challenge, but it does speak to the fact that our employees who work for this county who are committed to providing the services. The state makes a decision. State representative, speak with them as a district supervisor and also speak to them as a citizen. Does what I think he needs to do. Got more news in this than I do, and he's probably got more information and knowledge than I do. So, we're asking this resolution to is to defer to the citizens' decision. We lose half our police force because of this. How are we going to provide service? I mean, those are the drastic examples. But what about what about these other businesses that are not under our jurisdiction, but then their employer is bullied into a position and takes away that choice? That's why I stand, and that's why I support this resolution. I believe you have Mr. Fetch, the actual author of the resolution.
Sure. Do you care to comment? Mr. Kinsley, I haven't heard anything from you, sir.
Sometimes silence is golden. Go ahead.
I do have some comments.
Does not create any sort of cause of action or standing by an individual or an enforceable ordinance.
Are you talking about if it passes or if it doesn't pass?
Correct. If it passes, there's no creation of a legal right by virtue of passing this resolution. However, from a policy standpoint, if I may speak on behalf of certain supervisors, what does change is that the board is setting forth its policy and its beliefs that are memorialized in the resolution. So that's what would change if you adopt the resolution and defer to. So legal effect, none. Policy effect, yes. It could.
Because of how some people would interpret
right.
what this says and then take us to court.
However, I think with the revisions that we talked about at And you're correct that everybody donated. Action saying we should have been. That we talked about.
Seems to me that this is, as you said, it said, whereas Sawyer County government supports its employees and their right to choose decisions. I don't know how to say it, but it's the federal government and the state government. It's not Sawyer County. If it does come to that, this piece of paper is going to impress any of our county employees that we're any more willing to protect them because we won't be able to protect them.
So we've had plenty of good discussion here. I think it's time now to entertain a motion to either approve or deny or move forward with this or table it, or I'm opening it up to a motion. Anyone?
Make a motion to advance this resolution, either in its form or after the resolutions, or after the modifications that corporate counsel has recommended and will be incorporating for discussion and possible action for the full board.
Okay, motion by Mr. Schlender to move this resolution forward with the edits recited by
My
Ms.
motion
Roker.
also should be read to understand that it's not approved or denied by this committee. It's just being advanced for discussion and possible action to the full.
Got that, Lynn? Okay, motion. Looking for a second. I'll ask again. Is there a second to the motion? Is there a second to the motion presented by Mr. Schlender? No second. Motion fails for lack of second. Moving on to number 14, County Administrator's Report. Mr. Hoff.
Thank you, Mr. Chair. Couple items. Obviously, we've been working hard on the budget here last few weeks and months, and sending that again next week as well. So other than the budget information that we'll talk about again, a couple other items. The opioid settlement has been approved by the AG to participate in the settlement, so we'll be getting paperwork from the state. Decide if they're continuing that. Today, we do have a different carrier for health insurance. It's WCA that we had before. Looking forward to that relationship again. We had a construction meeting on Wednesday on the new courthouse. There's a full set of plans as they exist today here. Very easy. off. So I messed up. Guy, there.
Diversion programs to satisfy.
Towards that so that we meet that requirement. So I don't doubt that will meet that requirement. I mean, we're on schedule with construction that satisfies the state. We're working towards the treatment court component of that, and working on that progressively to the satisfaction of the state. So I think we're on target. But that is a component, yes.
And we're applying for that, what, planning grant? Or Justice Point
the
is?
TAG grant, we submitted an application for the planning portion of that, which would allow us then to get further down the road. And then there's supposed to be more funding coming out in 22 that we think we'll have a better opportunity of pursuing.
Thank you. Anything else for Tom, guys? Yes.
Brandon Schiff and his they keep asking me, giving me specs and something else regarding businesses in Surrey County. Somebody else. Is there any business that we're doing with this Collie business group out of Chicago? Are they sending it to the wrong person? Sorry,
Not aware of what you're referring to.
I'll send my house.
Okay. Anything else from Mr. Hoff? Yep. If not, we'll move on to number 15. Entertain a motion to go into closed session. Mr. Duffy may go into closed session pursuant to Wisconsin statute 19.851G to confer with legal counsel for Sawyer County, who is rendering oral or written advice concerning strategy to be adopted by Sawyer County with respect to litigation in which it is or is likely to become involved. Motion by Mr. Duffy, second by Mr. Kinsley. All those in favor?
Roll call vote, please.
Madam Clerk?
Dale Schluter,
Yes.
Reed Schumann,
Yes.
James Slender,
Yes.
Thomas Duffy, Ron Kinsley.
Yes.
Got the time in. Thank you all. Aaron, thanks for attending.
Yeah, I was